Good morning or afternoon, depending on where you're located. Welcome to another edition of NCS4, the NCS4 Forum Series. We're happy for all of you to be joining us today. Before we get started, I wanted to give out a couple of reminders and go over the platform very briefly. First off, you will see that there is a hand-raising function to this platform, but throughout the presentation, we encourage you to post questions. So we're not going to be working with the hand-raising function. If you're on a mobile device and you look at the bottom of your screen, you'll see a question mark there. If you're on a laptop or a desktop, on the right-hand part of the screen, you'll see a question mark there. So please feel free at any point during the presentation, as you have questions, we encourage you to go ahead and list those questions out in that section, and we'll be monitoring those. And we will have a couple of natural breaks to answer those questions throughout the presentation, and certainly on the back end of the presentation as well. We want to address as many things as we can. And if we're unable to get back to you throughout this presentation, we'll try to follow up with you on an individual basis after the presentation is concluded. After everything's said and done, this presentation, the video along with the PowerPoint presentation will be made available on our website, as is every presentation we've done previously. So we do encourage you to take advantage of those. We're going to continue conducting these webinars on at least once or twice per month. So we encourage you to keep an eye out for announcements of upcoming webinars, as well as if you have any interest in looking at any of those previously, they are listed on our website. So in response to the new normal, we've received several questions and requests regarding the legal landscape as we again prepare for that new normal and we start preparing to get back to business. So in response to your requests and suggestions and the feedback we've received today, we wanted to really discuss the legal issues and considerations as it relates to COVID-19. With us today, we're happy to have the partners with Pillsbury, Winthrop, Shaw, and Pittman. We have Brian Finch and Richard Giller. We'll go ahead and kick off the presentation with Brian this morning. So go ahead, Brian. I'll hand it over to you.
Great. Thank you, Daniel. It's a pleasure to be here. Really appreciate it. Thanks to Dr. Hall for allowing us to be here. Some of you may be familiar with me. I'm Brian Finch, obviously, with Pillsbury Winthrop, but I've also been a long-time advisory board member with NCS4, obviously starting with the legendary Dr. Lou Marciani. So I've spent a lot of time working on these issues over the past decade with the various members of the advisory board, attending the conferences. Sorry we couldn't do it this year in San Antonio, but looking forward to 2021 and beyond that. And very deeply involved in all the issues surrounding COVID-19 at my law firm. Helping to co-lead our COVID-19 task force on internal and external responses. That has been an extraordinary task, as you can imagine, as all of you are very familiar with at this point. Continue to be very involved in the sports and entertainment world, working with a number of clients on their go-forward plans for whenever the seasons reopen, whenever the arenas, the stadiums, the event fields reopen. And it's going to be really challenging, and I'm really glad to be joined here by my colleague Richard Giller out in Los Angeles. And Rich, maybe you want to introduce yourself real quick, and then we can dive into my slides.
Yeah, thanks, Brian, and thanks for NCS4 for having us. I really appreciate the opportunity. So I'm an insurance recovery lawyer, and I always tell the story that if I'm ever at a cocktail party and I tell someone I'm an insurance lawyer, everybody seems to move away from me. For some reason, and then but as soon as I tell people I sue insurance companies for a living, everybody comes right back and starts talking and give me all their stories about their horrors with dealing with insurance companies. One of my specialty niches, I guess, within the insurance recovery practice areas are sports insurance and entertainment insurance issues. So I'll touch on some of those when we get to the exciting subject of insurance later. Hopefully you guys will all be still awake, because I can put you right to sleep with some insurance talk. But happy to answer any questions anybody has. And, you know, while we're talking about legal subjects, neither Brian and I are providing any legal advice today, but we're happy to talk to you, offline if anybody has specific questions. We're always happy to talk, and I'll let Brian take it from here.
Great, thanks, Richard. Yeah, and it's we're actually really thrilled to have Richard join us here at Pillsbury. He is recently joined us within the past year, and it's really exciting to have him, especially unfortunately with everything that's going on with COVID and the rest of the world events. As many of you are probably aware, the issues surrounding insurance are just going to be absolutely critical, and hopefully can make up for some of the shortfalls that you all are experiencing right now due to the fact that everything has been canceled. And everybody is still under some degree of quarantine at this point. I think the only part of the world that is COVID-free at this point, allegedly, is New Zealand. And so we're not, since we're not really worried about Australian rules football right now, or rugby, although rugby will come up, and we're certainly happy to talk about Australian rules football and legal issues surrounding that. I think here in the United States in particular, this continues to be a very timely topic. And if we want to go to the first slide, Jacob and Daniel, it's been a really interesting few months. As one of my clients said, every hour is a new day when it comes to COVID. And I think that's absolutely right. And we can put aside everything else important that is going on right now in the world of sports and in politics. And our hearts are certainly going out to everybody who are dealing with the current situations regarding an introspective moment in American culture and racial history. But practically speaking, we're still extremely focused on sports issues and how to manage all of COVID. The first slide we have here is dealing with equal employment opportunity risks. This is a topic that has come up a lot, and Daniel and I have spoken about it, and Dr. Hall and others at the center. And what's really interesting to remember at the end of the day, and a lot of people seem to be forgetting, is that whether it's equal employment opportunity, privacy, which we'll discuss in a few minutes, or other issues, they still apply. The laws that generally apply have not been suspended. And so federal and state equal employment opportunity laws have not been suspended in the COVID-19 era. So there are still risks associated with the Americans with Disabilities Act. There are still risks associated with age and natural origin discrimination. All those things are really relevant. I mean, especially when you talk about age, natural origin. I mean, we could be getting down to issues like blood type when it comes to COVID at this point, because of the science we're learning with respect to the pandemic, and it's not going away. Just saw a comment this morning that we're seeing a new surge in cases in states like Texas and others. Could be tied to reopening, could be tied to better testing. We don't know as of yet. One person, Dr. Scott Gottlieb, who is the former chairman of the FDA commissioner, he said, we're not in the second wave, we're still in the first wave. And we're seeing increasing numbers of COVID cases in the Southern Hemisphere as well, so which probably equates to colder temperatures in those areas. But back to the United States, we still have all these issues to consider. And so it's important to remember that all these laws still apply. And then, so you still have to remember your relevant laws with respect to medical exams. Your rights as an employer are broader. You can do more like temperature taking. You can ask more questions regarding infections. OSHA, for instance, has required that if someone who is employed and on site as an employee announces or informs their supervisors that they've been diagnosed with COVID, OSHA now requires, for instance, as part of their enforcement guidelines, that you determine whether the COVID case originated at work or the transmission occurred somewhere else. So there are, in fact, a tightening of some of the employment laws that are going on at this point. And it's just a reminder that you need to be concerned with all of that. And so whether it's your in-house counsel, if you are in a school district or others, and you're school district lawyers, or you just rely on an outside lawyer, you still need to be very mindful of all of these considerations, whether it's ADA, whether it's equal employment opportunity laws, what's in a reasonable accommodation, et cetera. And as Richard said, we can only provide some very high level thoughts on this. If you have any questions, please feel free to reach out to us. But the basic point is that you need to follow your federal and state laws when it comes to employment issues, especially as people come back to work and you get more people. You not only have the employees, the ushers, the ticket takers, the field managers and maintenance crews, et cetera, coming back into work. You still have to remember all of these laws for them, and also be very mindful of the issues related to privacy. If we go to the next slide and talk about that a little bit. And when it comes to the privacy issues, this is going to be one of the most challenging issues. And I know Daniel mentioned this, that this is one of the hottest topics with respect to questions about the collection of data. And so we're seeing all sorts of questions raised about, well, what do I need to collect? How do I need to do it? So I'm normally in Virginia. Today I'm in South Carolina. Virginia and South Carolina are sort of polar opposites. In Virginia, we've just started being able to dine outside. Well, here in South Carolina, it's very different. You have some social distancing in restaurants, some people wearing masks. But I will tell you that in lots of stores we go into, you still have people taking temperatures. You still have people handing out hand sanitizer, collecting contact information for contact tracing. All this data is going to be challenging in the sense that if you collect it and you retain it, you may be creating a privacy problem for yourself and for your organization. And that's before we even get into more sophisticated issues like observations regarding behavior or surveillance cameras and using motion detection and facial recognition to track people. And that falls into the general context of contact tracing. All of that is potentially necessary. A lot of it is recommended by best practices and guidance that's been issued by health organizations like the CDC and some state and local public health agencies. What it doesn't do, as I alluded to in the previous slide, is that it does not relieve you of your privacy obligations. So especially if you're in states with very heavy privacy obligations like California, like New York, like Illinois, and I'll talk about it in a second, you have a lot to do. And you have a lot of obligations that are going to continue to be in place. And in fact, you probably have more obligations than you've ever had in the past with respect to the collection of this data and how you're going to handle it. And without being mindful of that, you could find yourself in trouble. Trouble for trying to do the right thing, unfortunately, but still finding yourself in trouble. And so if we go to the next slide, we can talk about some of these privacy issues in a little bit more detail. And I think what's particularly important to remember is that, especially for those of you who either are located in California or New York or are going to be encountering people that are either resident in California or New York, i.e. everybody, you have a new challenge in that there are new data privacy protection laws that have been established. The California Consumer Privacy Act, the New York Shield Law, both of those have dramatically expanded the definition of personal information and personal private information. What's most important here is that we're talking about biometric data. And so we're talking about the temperatures, we're talking about facial recognition, we're talking about recording movements of people, what their body behaviors look like, signs, sweating, etc. All that theoretically is covered under these new definitions of personal information. And so if you are rightly saying, I need to take people's temperatures in the crowd as they attend the ball game, when people are going to come to a college basketball game, we want to be observing and potentially recording people to see who looks like they're sweating profusely, who are showing signs of infection, and you record that to help with appropriate contact tracing. That's personal information, and that's protected under these laws, and it imposes upon you all sorts of new obligations, ranging from you need to have consent to collect this information, you need to properly protect that information, you need to delete that information when you were told when you get a request to delete it. And those are challenges. Those are significant challenges. And if you're not properly following your procedures, you could run afoul of the California AG or the New York AG's office. And believe me, those are two offices you don't want to run afoul of. They can cause a lot of problems, and without it's just a problem you want to avoid. And so you want to be mindful and understanding, and probably default to following rules like CCPA or following like New York Shield when it comes to collecting temperatures or reviewing surveillance video or tracking other information related to how people are behaving and responding or acting with respect in the COVID era. All of those are serious issues that you need to be aware of. The question has come up a lot with respect to HIPAA, and what's the interface with HIPAA and the collection of this data? It's a bit of a complicated answer, but the short answer is that when it comes to your employees and you're collecting this information, generally speaking, HIPAA could well apply if you are a medical services industry company and you are normally covered by HIPAA. But if we're talking about people in a crowd that are coming to watch a ball game, or you have students coming to attend a basketball game or go to a track meet or go to a concert at the local arena, HIPAA doesn't apply in those circumstances. So it's okay to collect that temperature information and log it. Now, again, you still may fall under some of these previous laws that I've talked about with respect to New York Shield and the state data breach laws, et cetera, like California Consumer Privacy Act. So you're not in the free and clear when it comes to collecting temperature information, generally speaking, but HIPAA is not a specific worry most of the time. Again, you want to do an individual analysis. You want to have a conversation with your compliance officer. You want to have a conversation with your lawyer to make sure you understand exactly where you are on that spectrum. But generally speaking, HIPAA is your lower priority. When it comes to privacy issues, it's the state data breach notification laws, the state personal information protection laws that are really going to cause a challenge. And just nota bene, we've seen a lot of discussions lately about the use of surveillance cameras, adding thermal imaging, adding motion detection, facial recognition, et cetera. Those potentially have their use. I wouldn't personally be in a rush to buy them. I think there's still a lot of questions regarding their effectiveness. If it fits within a larger plan, then you may want to proceed, but in the COVID context, I think they can cause a lot of pitfalls. And so you want to be aware of that and be very mindful of the privacy and security issues before you decide to go out and buy those cameras. So if we go to the next slide, Daniel, I covered a lot of this, but again, don't retain the data unless it's absolutely necessary to do so. If you are going to collect the data, remember consent, either written or posting a sign saying this area is under video surveillance. Get consent in some form. Protect the data. Can't stress how important that is. Any data you collect, if it's in electronic form, make sure it's encrypted, make sure it's secure. Don't just leave it in the clear. If you do, you're going to create all sorts of problems. I mentioned the disclosures with consent, and that also involves if you're explicitly covered by the California Consumer Privacy Act, or if you're covered by New York Shield or other laws, make sure that you have the right disclosures on your websites and other locations to allow people to inquire about the collection of that data and what's being done with it. And be very mindful, in fact, be very hesitant to share the data unless you are sharing it with public health authorities and there's some sort of explicit agreement. Otherwise, don't look at this as a data collection and revenue building operation. Look at this purely as a safety and public health operation. I did mention that there are some private bills that, congressional bills that are potentially offering federal privacy rights. I don't know where theirs are going to go, where those are going to go, excuse me. Everything congressional at this point is really up in the air, especially with the events of the last 2 weeks with George Floyd and potential reforms to police. That may well dominate the few days Congress has before its summer recess. Would also note that there's likely a need for a new stimulus bill, and so that's going to come up, and it's going to involve some liability protections, which I'm going to mention in a minute or two. But when it comes to something specifically privacy related, a standalone privacy bill, don't expect that as of yet. I think it may get wrapped up in something else, or it may get completely sidelined. It is just really unpredictable right now in Washington. It's really the best way to put it. The only predictable thing is the unpredictability of Washington right now, and state houses too. Just be blunt about it. So moving on real quick, we're going to then talk a little bit about, if we go to the next slide, we can start talking about the legal landscape too. And I know this question has come up a lot. It's something I've obviously focused on as a board member of NCS4 over the last decade, and also in my practice as well. But what I really want to mention here is that after 9/11, or actually I should start before 9/11, the rule generally was when it came to terrorist attacks that it was an unforeseeable event, and there was no duty owed to people you didn't have a contract with. So people coming to visit your stadium, visitors in your building, et cetera, if a terrorist struck. After 9/11, that changed. That changed dramatically. And what happened in those particular cases was that there were lawsuits related both to the 9/11 terrorist attacks and then also 1993, which I'll talk about in a second. But related to 9/11, there were a lot of claims saying defective products, defective security, health services, safety services, et cetera, negligent implementation. And everybody expected those to be dismissed because, after all, it was the fault of the terrorists, not the airplane manufacturers, not the building owners. Well, that's not what happened. What happened in those cases was that judges decided that a 9/11-like event, which to the government was an unforeseeable event, and in the courts was deemed reasonably foreseeable because there have been warnings about it. And because it was reasonably foreseeable, you had to take mitigation measures. In the case of Boeing, they had to design potentially hijacking-proof cockpit doors. And that opened up the landscape to tremendous liability claims, billions of dollars worth. And that created a lot of fear. And then on top of that, if we go to the next slide, people, it's hard to believe now it's almost 30 years since this happened, but the 1993 World Trade Center bombing, where there was a truck bomb that was detonated in the garage of the World Trade Center, almost knocking it over. And the plaintiffs there sued the Port Authority of New York, New Jersey, saying they provided negligent security, negligent risk management, et cetera. In 2008, 15 years after the bombing, so you can see how long the legs are in these cases, 15 years later, a court decided that the Port Authority was in fact responsible for the losses that were suffered on the 1993 World Trade Center bombing. And why was the Port Authority held accountable? Because it had a risk assessment that said someone could detonate a truck bomb in the parking garage because we don't have adequate security. And the court there specifically said if an event or risk was something you knew or should have reasonably foreseen or should have been aware of, then you have to take reasonable mitigation measures. Now, ultimately, in this case, the Port Authority was no longer held liable because it had what's known as sovereign immunity, meaning that as a government entity, its limitations didn't allow it to be sued in this particular circumstance. Side note, now what we're seeing with police reform, that may well be more important these days because we may be repealing that immunity in certain, especially with a lot of county or city-owned stadiums. And so I think that's going to be actually a very interesting issue going forward. Will the police immunity extend in that particular case? But going back to the main discussion here, the point though is that tied to the pandemic situation, you have a disease that people have been warning about a little bit, and we've had incidents in the past. Really, the last big pandemic was 100 years ago. We had some interim pandemics, nothing that really struck the United States. We had scares, but there was discussion of it. And this is the type of decision in New York where you could say, well, you should have been aware of the possibility of a pandemic. And now I think even more important is that this pandemic isn't a moment in time, okay? We're not talking about a singular incident at one moment, like a bombing of the World Trade Center or the 9/11 attacks. We're obviously talking about months where we're now aware of the risk and the threat. And so there's no question at this point that you have to take reasonable mitigation measures. Everybody's on notice at this point. And so what does that mean? And what does it mean if you fail? Obviously, it means potentially significant liability. And lots of lawsuits saying if it wasn't for you holding your game, it wasn't for you holding your concert, your craft fair, whatever it is, we're going to sue you and we're going to hold you accountable. We want damages. We want all sorts of damages. So if we go to the next slide, there has been some discussions about, well, how do we manage that from a statutory perspective? What are the liability protections that are available? Some states are passing liability protection laws. New York, New Jersey, and Michigan, for instance, have limited medical malpractice liability. That's good. However, there's no general liability protection that has been passed as of yet in Congress. Currently being debated, very hotly debated, the Senate Majority Leader, Mitch McConnell, has demanded its inclusion in the next stimulus package. And I say this as a completely apolitical comment. Mitch McConnell is an extraordinarily effective Senate Majority Leader. You may not agree with what he's trying to accomplish, but he's very good. What he wants, he typically gets. And so if he says that he wants to include liability protections in the stimulus package, you can at least expect that it's going to be a very serious discussion. So if we go to the next slide, what could that look like, and what are some of the other statutes that are already out there right now? There's one that's been discussed, the PrEP Act, the Pandemic Readiness and Emergency Preparedness Act. It possibly covers some of the products that are out there. It does cover drugs and medical devices like respirators, like ventilators, some of the drugs that are being used right now, both as like aspirin and some of the other drugs, the antivirals that are being used as some of the experimental ones. They're covered and they have some liability protections, and it could cover you as a facility owner if you're distributing those devices or those drugs, as I know some are. They've been turned into testing locations distribution sites for personal protective equipment and others. But it's not very broad. It doesn't cover services and policies and procedures. There's the Safety Act, which is my specialty. That's not going to work because it only applies for terrorism, but it can apply in the context of if you've had disease management, if you've had safety, security, hazardous material response, disease control, all of which are potentially part of a Safety Act application. And we, in fact, have covered at Pillsbury for a number of our sports and entertainment facility applicants. You can, if DHS has vetted those, you can point to that in court and say, we had DHS review our disease management, our hazardous materials response, our cleaning processes. So DHS has determined that we are effective and useful in managing diseases. It may not have been specific to COVID, but it covers our processes generally. So how can you, plaintiff, just come in and say, oh no, they were negligent because someone got a disease? You're going to have to push back against the DHS conclusion that you're doing a very good job. That's where the Safety Act could really be useful in this particular case. If we go to the next slide, and I'll just wrap up real quick and then turn it over to Richard. I mentioned here applying the Safety Act to push back. Again, you're acting on public health information. You've implemented reasonable screening measures. The screening measure for someone showing symptoms of a disease versus nervous behavior because they may be carrying an explosive device or a weapon. It's really the same thing at the end of the day. It's obviously different, but it's really the same in terms of you have training, you implement it, you have supervision, you have auditing, and you have continuous improvement. So in that context, it's the same. And it goes all the way to incident response procedures. If you identify someone who's clearly sick, how do you manage that? Those are examples of what you can factually push back on related to the Safety Act and how it can be useful in that context. So everybody should be thinking about that as well for those of you who have Safety Act applications in process or are thinking about implementing them going forward. And then for the next slide, just going for any questions there. There's our break, Daniel. So I think we're ready.
Absolutely. So at this point, we wanted to answer a couple of questions. I know we still have some content to cover, and we'll get back at it pretty quickly here. And it looks like one of the big questions we've received so far, there is a question regarding insurance, and I'm gonna put a pin in that one until we get to Richard and he starts diving into the insurance world. We know we've seen some stuff going on as of late. Most recently, we saw Coachella being formally canceled for 2020. So again, we'll discuss the insurance piece to that here shortly. But one of the things that's come up is people are looking for a good resource where they can review all of these things you're talking about. So what's a good reference for them to look into as it relates to privacy laws for their organizations? Is there a good space they can go to that almost breaks it down into layman's terms, or at least compiles the information they need to be aware of?
Yeah, we actually have a lot of resources. For instance, at our website, pillsburylaw.com, we have a COVID-19 resource center that discusses a lot of the privacy laws specifically there and how they apply. We have a number of alerts, and so I think that is a very good location itself. I know Stanford University, Stanford's law school, has also put out a website that has some information on privacy. There's also the International Association of Privacy Professionals, IAPP.org, that has been printing a lot of materials on privacy and other issues like that. But a shameless self-promotion of Pillsbury in the sense that we've got a lot of great alerts on there. I know we've written a lot of them. I participated in some of them. We have presentations like this. And so you can look at that website, but I would recommend IAPP as well as other professional privacy organizations to take a look at for this type of information.
Fantastic. We also had a question, what type of liability concerns, and maybe this kind of skirts into Richard a little bit as well, but what types of liability concerns are there related to the virtual events? As many are running races, a lot of things we're seeing go virtual now. So what types of liability concerns do we need to be mindful of?
So liability in the virtual events is mostly related to privacy and data theft. In that particular case. And what I mean by that is that in the hurry to stand up these virtual events, there's a lot of focus on reliability and stability of the virtual environment and the virtual experience. And so security and attention to privacy may lag a little bit. I'm not saying that people are deliberately ignoring it, but what I am saying is that as more people, record numbers of people go to look at these virtual events, privacy sometimes lags or security systems just get overwhelmed. And so it's the potential that people's personal information, which can go all the way to their unique internet protocol identifier now under California law, or their logins or the credit card information, that's the type of liability. It's that online data breach, personal breach of information liability risk that I think is the most critical one at this point.
Absolutely. And before we continue, because I'm going to stop the questions there just to make sure we give ample time to cover the rest of the presentation. We're definitely going to have some other segments for questions. And on the back end, if we understand some people have to get off at the top of the hour, but if we need to run a little bit over, both of our presenters we're gracious enough to stay on a little bit to answer any of those questions we might not be able to get to during the presentation. So we do have some more questions coming up. Before we start off though, I did want to mention, I did notice that some of the text is off on the bottom of the slides. I don't know what's being misinterpreted between the computer and the web platform, but I can promise that the version that we share with you after the fact will not have any of those issues. So I do apologize for any other slides we might have that are a little bit off on the bottom. So with that said, we'll go ahead and pick back up with the presentation.
Thanks, Daniel, and nice job, Brian. So now we're going to go to the most exciting topic of all, which is insurance and its various impacts and concerns in the COVID-19 world. So I thought I'd start with just a little kind of introduction into insurance. There are basically two types of insurance policies. There's first-party insurance and third-party insurance. First-party insurance is basically a property insurance policy that you or your company has or a school has, where the loss is something that directly impacted you individually or as a university or company. So it's not somebody suing you for something, but a fire or hurricanes or property damage, and so that's a first party policy. We'll talk a little bit about third party insurance a little later. So one of the first policies that have really responded to the COVID-19 pandemic losses is event cancellation insurance. And as the title of the policy sort of implies, it's an insurance policy taken out to cover a specific event. It could be a one-day event, it could be a week-long event, it could be 2 weeks long, but it's a specific event as opposed to, an entire academic year or an entire sports season. And before January 24th of this year, you could buy an event insurance policy, which is a first-party policy, that included coverage for communicable diseases. So cancellations, postponements, or suspensions that arose out of communicable disease, like COVID-19. And just as an aside, most people don't realize that there is the virus, coronavirus, which is actually, the title of it is SARS-CoV-2, and then there's the disease that arises from the virus, which is COVID-19, which is coronavirus disease 2019. So COVID-19 is the designation for the disease, and in some insurance policies, the difference between a virus and a disease may be the difference between coverage and no coverage. But Brian was talking about, this is the first major incident like this where we have so many deaths, but it's actually the 7th pandemic or epidemic of the 21st century. The SARS epidemic came out in 2003, and then you had swine flu, and then there was something called MERS, and then you had Ebola, avian flu, Zika. The difference between all of those is all of those combined caused worldwide deaths of about 600,000 people. And so, and nobody shut down. Nobody stopped businesses. Nobody, had social distancing and masks and all the issues. But back in 2003, when SARS first hit, the insurance industry was pretty quick to react. They're not really good about predicting stuff, but reacting they're pretty good at. So in 2003, about 30 days after SARS became an issue, they started issuing exclusions for the SARS virus. The same happened this year. So before January 24, you could buy an event cancellation policy and pay about 15 or 20% additional premium to secure communicable disease coverage. Those companies and organizers and events that purchase those are getting paid off right now. we'll give a couple examples here. We can go to the next slide. But after January 24 of this year, insurance companies have universally started excluding and issuing exclusions for COVID-19 specifically. They identify the virus and the disease, and they have a specific exclusion. One issue that has come up, and it's not in the slide, but if this has happened to you, please reach out and talk to me about it. Some companies and organizations had insurance policies before COVID hit. And then the insurance company tried to slip in an exclusion in January or February of this year to an existing policy. Those are most likely not valid. You can't change the terms of a contract after it's been negotiated and paid for. So if that's happened to you, you know, contact somebody, contact an insurance recovery lawyer to discuss it. The other major first party policy that has come into play since the outbreak is business interruption insurance. Sometimes it's called time element coverage as part of a property damage policy. There, it usually requires physical damage to property or physical loss or some physical aspect of it, even under the coverage portions listed on the slide. Civil authority is the biggest one, where your business or organization has been shut down because of a government order telling you can't have access anymore, which obviously applies here. So the big question in triggering business interruption insurance is whether or not there's physical loss. You would think that, you know, some people think that physical loss requires structural damage to the building or facility itself. It does not. Most cases across the country, and in fact, the majority of courts say physical damage could be from the inability to use the building, an outbreak of E. coli bacteria, you know, gases and noxious fumes, all have triggered business interruption insurance claims. But this is the biggest battle area right now. And just like everything else, Congress is considering something called the Pandemic Risk Insurance Act, which will serve as sort of a backdrop. They just released, or they're talking about the new bill that was introduced recently, and it includes events, entertainment events, and sporting events for the first time. A similar type of insurance act was introduced after 9/11. It was called the Terrorist Reinsurance Risk Insurance Act. So you have TRIA for 9/11, and you have PRIA for COVID-19. If we move to the next slide. So a number of organizations, like I said, Daniel, if you could go to the next slide. In any event, so a number of organizations had realized that, you know, communicable disease was a possibility. So they, you know, some events like Wimbledon, the British Open, the NCAA for March Madness, they all had event cancellation policies in place. So it's the next slide, actually, Daniel. There we go. So after SARS hit in 2003, Wimbledon decided they should have communicable disease coverage. So for the last 17 years, they've had an event cancellation policy with communicable disease extension, and they paid about $34 million to have policies over the last 17 years, which seems like a lot in premiums, but they're fully covered this year. Their cancellation of the tennis tournament for the first time, I think, since World War II, they are covered for somewhere between $150 and $300 million in insurance proceeds, which they are going to collect because they've had the foresight to buy the communicable disease coverage. Now, I want to tell you that if you don't have communicable disease coverage on your policy, that doesn't mean you don't have coverage. Coverage can be triggered in any number of ways under any number of theories. If you have communicable disease as part of your event cancellation or your business interruption or property damage policies, you most likely have coverage as well, or at least a good argument for coverage. So some conferences within the NCAA had event cancellation policies for their championship tournaments, and those are paying off as well. So the Big East and Atlantic 10 are among those conferences, and then there are some conferences that didn't take out event cancellation insurance. So if we move to the next slide, the March Madness is hands down the biggest event for the NCAA. It accounts for about 70% of the NCAA's revenues in 2019. And years ago, the NCAA came up with a risk mitigation plan to try and figure out, what do we do if March Madness is canceled? March Madness accounts for about $800 or $900 million a year. So they hired a CPA firm and made a decision that they were going to buy event cancellation insurance, which they did. And when they first purchased it, they had about $250 million in coverage. And then over the years, NCAA had collected and had in their coffers about $500 million in cash that they just had as an extra resource in case something happened. But like most governments and companies, if all of a sudden you have a bunch of cash sitting around and nobody's using it, they forget about the risk mitigation aspect of it, and they decided they would use that money and spent it. Well, they spent the $500 million, but they never increased their insurance policy limits. So what should have been a $600 or $700 million limit on their policies is only 225. And last year, the NCAA distributed $600 million to colleges and universities for their athletic programs. And this year, they're going to distribute $225 million. So that shortfall is going to hit colleges and universities extremely hard. One of the, if you go to the next slide, Daniel, one of the little known aspects of how this shortfall will impact athletes, the NCAA has something called the Student Assistance Fund, which for years has been used as sort of a extra amount of money that colleges and universities had to pay for things like, somebody's grandfather passed away and the student athlete can't afford to fly home for the funeral, or they can't afford to buy a laptop because they just don't have the financial resources. Well, about 5-6 years ago, schools started using Student Assistance Fund money to purchase insurance policies on student athletes. The 4 types of policies are listed on this slide. And most schools use it as sort of an internal recruiting measure. Stay in school an extra year, don't turn pro, but we'll make sure we buy an insurance policy for you in case you get injured during your last season. So the Student Assistance Fund in each school has been used to buy these policies for the top athletes, the ones who have, potential first, second, third round draft pick in the various professional sports. Well, with the cutback from 600 million to 225, there's going to be a significant cutback on Student Assistance Fund money as well. And that means that some of these athletes will not be able to get insurance coverage paid for by the colleges and universities. So if we move to the next slide, Daniel. So we've talked about event cancellation, business interruption, insurance, and then of course every college and university talks about other risk shifting mechanisms. Those all need to be explored now because as of January 31st of this year, you're not going to be able to buy communicable disease coverage. You may not be able to buy communicable disease coverage for a year or two, or maybe ever again, given the scope of the damages. People are estimating that the insurance losses for COVID-19 are going to dwarf anything we've seen before, probably more than all of the hurricanes we've seen in the last decade or two, and maybe those plus the 9/11 insurance recovery aspects. We're talking about tens of billions of dollars, and like I said, that Congress is considering passing a PRIA to help in case insurance companies are going to go belly up with all the claims. What we're seeing right now, though, is most insurance companies are shockingly not agreeing to pay on business interruption claims. They're denying most of the claims that come in, which is sort of standard operating procedure for most insurance companies. But don't let that deter you. If you get I've always said the larger the claim, the more likely you're going to get a denial. And what usually happens is you get a 20-page denial. It looks imposing and like something you can't fight. But the insurance companies are all betting on that. They sort of bet on the fact that they deny initially, and somewhere between 70 and 90% of the people who get denied will just drop off. They won't fight it any further. So then if you challenge their initial denial, hire a lawyer and go after it, then they send out a second denial letter, and that's even longer with more policy language included. And so it's sort of a step-by-step sort of standard operating procedure for most insurance companies. The one thing that's going to be clear following, when we get back to reopening and somewhat of a, back to normal, you're going to find it harder to find insurance policies in general, because there are going to be some insurance companies that won't be able to pay all the claims and they may just go belly up. And you're also going to find that, business interruption coverage may be more expensive to purchase in the future. But again, you should, that shouldn't deter you. You should still look for insurance policies and figure out how best to use them. And any claims you have now, you should talk to your risk management people. You should talk to your general counsel, outside counsel, and everybody should look at every single insurance policy that is in place and currently in place to find out if there are coverage grants that may trigger, payments under this for these losses. It's very important that you put everybody on notice, that you look at the notice provisions of every policy, that you look at the proof of loss notice provisions in first-party property claims, because those policies usually require that you submit a sworn proof of loss documenting all your damages within 60 or 90 days of an event. So what we've been doing is advising clients to ask for a 90 or 120-day extension of the sworn proof of loss, because right now, until you reopen and you can actually figure out what your losses were and have been and what they're going to be, you don't really know what your losses are. So documenting your losses is critical right now. Putting your carriers on notice is critical right now, as is making sure you read all of the notice provisions in your policy and seek extensions of any of those. So I think that takes us to any questions about, the first part of the insurance presentation. Daniel, on the next slide, we can either pause here or I can keep going, whichever you prefer.
At this point, let's go ahead and push forward so we can get to, I know you still have a few more slides to go, and then we'll go ahead and break for questions at that point.
Great. So risk mitigation is very important for universities, colleges, businesses, everybody. This is where we get into a brief discussion of third-party insurance. So third-party insurance is triggered when an organization is sued by somebody based upon their actions. And third-party insurance differs from first-party, not only because you're being sued, but first-party insurance policies include both a duty to defend on the part of the insurance company and a duty to indemnify, meaning that the insurance policy covers you for a lawsuit filed against you, and then if you get a judgment or settlement, it should cover you for the cost of that as well. However, what many courts recognize is the duty to defend, the ability to have an insurance company pay your defense costs in a case, is probably the most important aspect of most insurance policies, because people hear about, I have $1 million worth of coverage. So you have a $1 million insurance policy, but the costs of defense are not capped, and they're not normally part of that in policy limit. I had a case one time where there were $30 million worth of insurance limits, but the insurance company ultimately paid my client $250 million in settlement because they had defense costs in a $500 million underlying case that they were responsible for paying. An insurance company can't just pay your policy limits in a third-party case and get out of having to defend you further or pay the policy limits. So third-party insurance is important. The other types of risk mitigation post-COVID-19 is going to be waivers, releases, affirmative consent forms, acknowledgement forms. This applies to students. It applies to employees of the university. I read somewhere that there are 4 million people employed in the higher education sector, and that sector accounts for about $600 billion of the United States gross domestic product. So employees and all of these types of people need to do releases, affirmative consents, acknowledgements. And no matter how they're written, no matter how airtight you think they are, the reality that all of us are going to face is there will be lawsuits. No matter what you do, no matter how many guidelines you implement, no matter how faithfully you execute them, you will be sued. Someone will sue you, which is why third-party insurance and reviewing those right now to find out what kind of coverages you have and what kind of exclusions are in those policies is important, because somebody other than the college or university should be paying the defense costs if someone sues you. Now, the last bullet point on this slide is important. With respect to reopening, whether it's sports, whether it's college sports, pro sports, whether it's just reopening colleges and universities, establishing a set of guidelines, and that can be, you know, extensive. The motion picture and television production unions and studios in California just submitted a 22-page outline of all of the guidelines. Florida has a 6-page outline. Colleges, various conferences have come up with their own guidelines. The key is to avoid liability in terms of having to pay a judgment or settlement. You create a set of guidelines, you follow them, you document that you followed them, and in that instance, you probably won't ultimately be held liable, but that doesn't mean you won't be sued. So again, that's pretty important. If we go to the next slide. So just like Brian was talking about with the Security and Safety Acts, a number of colleges and universities met with Vice President Pence and Education Secretary DeVos a few weeks ago to talk about the issues regarding reopening. And one of the big issues is we need some sort of immunity. We need immunity from liability. And as Brian's slide pointed out with Mitch McConnell, that's one of the things that they're really considering right now, whether it's going to be a 6-month immunity or a 12-month immunity. It's a big, important topic of discussion, and it's going to be one that most likely will be addressed by some type of legislation, whether it's state or federal. The immunity safe harbor, you know, question has triggered a lot of debate, and there's a huge debate just between that, shockingly, goes along party lines. Democrats are fearful that if you provide immunity, then the people you're providing immunity for, the entities, are less likely to, you know, be worried about the health and safety, and they're not as worried because they don't have legal liability. And then the Republican viewpoint is, in order to reopen and get the economy going again, you need to have some protections like this. So one of the big sticking points is gross negligence, willful misconduct, and intentional harm would be excluded from any type of immunity. The interesting part of that is the waivers, releases, consent forms we talked about a few seconds ago. Those don't apply to gross negligence, willful misconduct, or intentional harm anyway. So it's really not a big, you know, leap to go from some type of limited immunity. The other issue is not just limiting in terms of making it a temporary immunity, but also very targeted, very specific types of immunity being provided. So if we go to the next slide, Daniel. This is what I was talking about with establishing some type of guidelines, whether you have to follow the CDC requirements, whether there are state and local requirements that are a little different. The key is establishing some type of guidelines. Then the key is also documenting that you're following those safety protocols and guidelines, that you keep copious records, that, you know, if you're supposed to sanitize once or twice daily, that somebody documents that happened, because the key for immunity and liability and issues regarding lawsuits arising out of this is all going to be, what was your standard of care and did you follow it? If you followed your standard of care, you're less likely to be hit for a judgment or settlement. So documenting it all. For sporting events, you know, assumption of the risk is a big issue in sports. If you buy tickets down the first base or third base lines in a baseball game and you get hit by a foul ball, the back of your ticket has an issue about assuming the risk of the sports. And same with ski resorts. You know, the normal standard risks So one topic and a suggestion I've made to a number of colleges, universities is everything should be an electronic ticket now. So any sporting event you have, if you have fans that are coming in, issue electronic tickets. And as part of the electronic ticket, you have an assumption of risk laid out with regard to COVID and SARS-CoV-2. You have a release and you have a waiver in there, and then they have to check the box before a ticket can be issued. Something like that, where you don't have physical tickets. And then, you know, you've got all the privacy issues that Brian talked about with regard to tracking. How do you implement social distancing in arenas and stadiums? Issues regarding whether athletes should be tested more frequently than the general student body. You know, those are all issues that everybody's going to be struggling with. One of the things I keep telling all my clients is you have to recalibrate, you have to be able to pivot, you have to have collaboration between and among all of the various entities that you're dealing with, and open and honest communication about it all is going to be key. So if you keep those in the back of your mind, you know, I think you'll be okay. If we go to the next slide, these are just some ideas about, you know, returning to sports. Most of the pro sports talked about, you know, doing fist pumps instead of high fives. Now I think everybody says no fist pumps, no high fives, no handshakes. So just don't touch each other, basically, is the issue. And then fan interaction. You know, a lot of colleges and universities have long traditions of the fans being able to you know, root their players and their fellow athletes and students on. And so those will probably have to be eliminated or changed significantly. If we go to the next slide, I'm going to run through these really quickly because I see we're coming up on our time. You know, Governor Newsom in my state announced a month ago that, you know, there will be no mass gatherings until 2021. He's since switched that. Last week they issued orders that allowed sporting events to take place in 2020, but there may not be any fans. But if there are different regulations and orders between different states, and you have competitions between and among different states, you know, that's going to be an issue. If we go to the next slide, you know, you've got issues with regard to scheduling and flying back and forth, and maybe you're going to have to travel by bus more, and there's going to be all sorts of changes. And like I said, you're going to have to recalibrate and be able to pivot. You're going to have to be flexible and you know, acknowledge that this is a fluid situation that changes sometimes hourly, sometimes daily, sometimes weekly. So just keeping all those in the back of your mind will probably be very beneficial for everybody. And I think that's the end of my section, Daniel. So if you want to jump to questions, I guess we can jump to questions. And I'm sorry, Daniel, but the slide you have up right now, Brian and I are both the types of lawyers that if you have a general question, reach out. We don't have to set up a new case or bill you or set up a retainer. Reach out and we'll be happy to try and give you some general, very overviews of what you should be doing, and then tell you if you need to hire a lawyer to go forward, because
That's right.
you know, again, we all need to collaborate in this era and keep moving forward together.
Yeah, thank you both for the information. I know it was extremely informative. This has been a topic that's come up time and time again. And I know we still have a long way to go and we have a lot to learn. And this is a constantly evolving landscape. And I know for NCS4's purposes, we want to continue to track some of those changes and make sure that we're informing and educating our industry the best we can. So, but before we get into questions, I do know that it is the top of the hour, and we certainly understand anyone who does need to get off. Everybody, it seems that we're loaded down with meetings, virtual meetings right now. So we definitely understand if you need to log off. We will make this available on our website after the fact. Again, the one we make available on the website, we will clean up the slides. I'm not sure what the issue was there in the interpretation, but we'll make sure we get you guys those slides and that information. So please, we encourage you to take advantage of those after the fact. We'll get as much information we can to you. So again, we do understand if you need to leave, and this will be available after the fact. So a couple questions that did come up, and this one's probably more for you, Richard. I mentioned Coachella earlier. There was a specific question related to Coachella, and I know you skirted on it. Well, you actually touched on the topic, but specifically, they said with Coachella being formally canceled in 2020, will insurance consider infectious disease as a force majeure going forward?
Well, force majeure clauses are usually between contracting parties. So whether or not it's force majeure is not as big an issue, I think, as whether or not Coachella has event cancellation insurance in place. As I understand it, they did not have communicable disease coverage on their event cancellation policy, but that doesn't mean they don't have insurance. One of the big issues on event cancellations like that are ticket refunds, and is it enough to just offer you tickets for 2021 when it comes back, or do you have an obligation to refund the price that people have already paid? So there are going to be a bunch of issues that come up, and insurance will play a part of all of that.
Absolutely. Another question, and this one gets a little more specific, but I know that we work with a lot of emergency planners, and we're at a point where we're really looking at revising and incorporating social distancing guidelines and CDC regulations. So we're incorporating all these new things we're learning and these new guidelines and governances. So specifically, a good example that was brought up was typically we've had to shrink down our capacity to 30,000 people. So let's say they've already done social distancing, so 30,000 people. But if there is an emergency and they have to emergency shelter the people in their stadiums, and let's say their shelter space, they can't conform to those social distancing guidelines within that shelter space. Are there any type of legal issues they can see coming from that? So again, they're going to have to break social distancing, going from respecting it at a limited capacity to breaking those social distancing confines with emergency sheltering. Do you see any legal issues there?
Well, sure. I mean, you could see a legal issue with anything. I think what people, where the liability could come up, or the questions that will be raised would be that, well, do you have personal protective equipment that you can distribute to people as they get into closer quarters, and they have to break the social distancing of 6 feet. 6 feet, by the way, is a totally made up number. I'm sure Richard and I have talked about this, and I'm sure you've heard this, Daniel. You look around the world, the number's different in every country. Based on some conversations I've had with government officials, it's literally made up in the sense that they, as the pandemic broke out, they just looked to see what the 2003 SARS social distancing numbers were. It was 6 feet, and that became the number for COVID-19, even though there's no science behind it. So that is a possible defense. But the point, though, is that if you are thinking about this, then precedent would say that you need to think about, well, how are you going to control disease transmission in closer quarters where you can't manage social distancing? And if you didn't address that, then that potentially exposes you to liability. So you'd have to think about, again, like personal protective equipment, decontamination, or sanitation issues with antivirals, hand sanitizers, et cetera, and making that available, trying to minimize the time in close quarters, because it's not just if you happen to walk through a cloud of COVID that you're going to get it. There is science related to viral load and the time of exposure, et cetera. So you want to try and take all that into consideration and document that as you put that together to protect against any claims that would come up. They're virtually certain, as Richard mentioned, to come up in some way, shape, or form, but some are more legitimate than others. Let's put it that way. And so the advice I think I would be giving generally in this case is to try and make sure that you have scenarios and plans where social distancing isn't practicable or possible to continue to mitigate, not eliminate, the possibility of disease transmission. And that's really an important point overall, is that this is really about risk mitigation, not risk elimination when it comes to COVID. I mean, if we have a vaccine that's 100% effective, then we get to risk elimination. Barring that, we're always in the risk mitigation manner, just like we are with terrorism and crime and safety related to alcohol consumption, those types of issues.
Absolutely.
Another issue that's going to come up, Daniel, in lawsuits. Let's say you have social distancing in place and you're working at 50 or 30% capacity in stadiums and arenas, and then the college or university gets sued for somebody that has, now contracted COVID and they claim that they got it at the event. Causation is going to be a huge issue for plaintiffs. How do you prove that you didn't get COVID because you went to Target? How do you prove that it was when you're at the, 50% capacity football or basketball game. So again, that goes down to liability and whether you actually owe a settlement or a judgment, but you're still going to get sued and you're going to have, costs of defending those cases. So all these issues are going to be litigated, and most of them are going to be, first of their kind litigations that courts and you're going to have differing opinions and differing standards in differing states and throughout the federal court system as well. It's going to be a very interesting time for sure in the next 2, 3, 4 years.
Yeah, the causation point is an extremely important one because it's going to be challenging. Now, I think we can all stipulate that college students are well known for following rules, not gathering in tight spaces, and being religious about their sanitation and hygiene practices, especially at events where under 21 the alcohol rules are strictly enforced. So there's only one possibility, right? That it was at the sports stadium. Obviously, there's going to be lots of potential causations, usually involving 3 Greek letters, that could potentially be the sources. And so, plaintiffs do have a challenging road in front of them. But as we've seen in lots of cases in courts, there's also an appetite to punish the university and punish the entities with deep pockets, saying they should have known better. So while there's going to be lots of defenses, the downside is particularly expensive.
Absolutely, and I know we're officially out of time, but we're answering a couple of questions. I do have one more question, just because I don't want to oversee this one, and it's certainly a unique question. It is sport specific, but we know that as we've virtualized a lot of our operations and we've continued to try to maintain those touch points and work together, that there are a lot of organizations that are encouraging people to take part in physical activity. Marathon Community is a good one where they are encouraging those virtual runs, and they're organizing those as such. So the question is would organizers be held liable for any participant getting injured in taking part in those physical activities that they've organized?
Well, I mean, the first response to that is, I don't think a virtual marathon has any different standards than if you actually ran a marathon. And if somebody pulled a hamstring during a marathon, the organizers aren't liable for that. It comes to a duty of care. And the duty of care for an in-person live sporting event is going to have to be a little higher than a virtual one. I tripped in my bedroom, on my treadmill because I was doing a virtual marathon. I don't know how that's the organizer's fault, but as Brian and I have said throughout this whole presentation, that doesn't mean you won't be sued for it.
Right. It's sort of, I remember studying for the bar exam, and the torts bar review professor, offering examples of silly warnings like the sunshades you put in your car, and on the back of it somebody printed, "Do not drive with sunshade in place," right? There's always that, and I suspect that if that virtual liability were present, we would have already seen a lawsuit against Peloton or someone like that for someone who may have injured themselves or suffered some sort of cardiac event during a rather vigorous virtual exercise. But again, you never know. There's lots of creative plaintiffs out there, and there are a lot of judges that are willing to entertain novel theories of the law. And it could well be that as things move online and become more virtual, there are going to have to be increased warnings about, you're in a place doing this by yourself, you need to make sure that you're properly fit. Or just the standard warning saying if you have high blood pressure, heart disease, or other issues, kind of like when you get on Splash Mountain at Disney World, there may be that warning before you go into the virtual Boston Marathon or the like.
Fantastic. I mean, again, I know there are still a couple of questions out there, and some of those questions we'll try to get back to you on an individual basis. We certainly encourage you to reach out to us at NCS4. I know that we have, if we could go back to the slide, with the contact information. You can also reach out to either one of these gentlemen with anything specifically that they've mentioned during this presentation. Again, we all want to be a resource for you as we continue navigating this new normal. So before I close down, are there any closing remarks from either of you, Brian and Richard?
I'll just start and say thank you so much, Daniel. Really appreciate it. It's a wonderful opportunity. Always great to interact with the NCS4 community. And this is an ongoing issue. I don't think this will be the last conversation we have about insurance or liability. It's every day is something different. Just if there's one piece of advice, document what you're doing, and the day you document it on, because the science changes so much and the advice changes so much that you want to make sure that you can reflect that what you were deciding and what happened was reflective of the best advice to that point.
Yeah, and my advice would be flexible, be willing to, rejigger what you're doing and try and figure out the best way to, keep everybody's health and safety at paramount concern. And don't be afraid to ask questions. Ask questions of your risk advisors, of your general counsel, of outside counsel. Reach out to anybody just to try and get some advice as you try and navigate these waters. They're unusual and unknown, so trying to get advice and presentations like this are incredibly helpful. So thank you very much for letting us have a chance to talk to everybody, Daniel.
Absolutely. And again, thank you all for participating. We look forward to putting on many more of these in the near future. We are just trying to, like everyone else, trying to figure out the best ways to communicate and coordinate with everyone throughout our community. So we do look forward to having you back in the near future. We'll continue to try to get information out. And again, we will make this presentation available on our website here within the next day or so. So encourage you to take advantage of that, share that with anyone who might benefit. Ultimately, that's the goal. And please reach out to us if we can do anything for you or work with you in any capacity. We are all learning as we get ready for what is the new normal. So again, thank you. Happy Thursday, and wishing everyone a safe and good weekend.
Great.
Thank
Thanks.
you.
All right. Thank you. Bye.